Welcome to The Explainer. Today we are setting sail, literally, into a really unique and, surprisingly powerful corner of the legal world. This is the law that governs the vast oceans and pretty much everything that travels across them.
So let's just dive right in, shall we? The answer to that question, which is kind of weird when you think about it, lies in this really specialized, centuries-old legal system that, believe it or not, affects nearly everything you own. We're talking about Admiralty law.
All right, so first things first, we gotta ask why. Why in the world do we even need a separate law of the sea? To really get a handle on that, we have to look at the huge problem it was created to solve in the first place.
I mean, just think about it for a second. Ships. They're constantly on the move, right? They're crossing all these international borders. And they face unique dangers you just don't see on land. Crazy storms, piracy, you name it. Imagine trying to apply the local laws of every single port they visit. It would be absolute chaos. So you absolutely need one single uniform set of rules.
And that's the whole ball game right there. This is the core principle, and it's so important it's actually written right into the U.S. Constitution. At the end of the day, Admiralty law isn't just about boats. It's really the legal operating system for the entire global economy. It's what makes sure trillions of dollars in goods can move across our oceans smoothly.
Okay, so we've established we need this special law for the sea. But what's the trigger? How does some random incident get pulled out of a regular court and into this special federal legal world? Well, it all boils down to two key tests.
So it actually works in two different ways. See, for cases involving some kind of harm or injury, what lawyers call a tort, it's all about where it happened, on navigable waters, and that it has some connection to maritime activity. But for contracts, it's totally different. It doesn't matter where you sign the thing, it's all about the contract's purpose. The big question is this agreement fundamentally maritime in nature?
Now, what's really fascinating here is what's not on this list. For these really weird historical reasons that frankly still baffle a lot of legal experts, a contract to build a new ship or even to sell one isn't considered a maritime contract. It only becomes a maritime issue after the ship has actually been launched and is in the water. Go figure.
And this, right here, is the key to that whole jet ski question from the beginning. See, navigable waters doesn't just mean the ocean. Nope. If a lake or a river connects different states, or connects to the sea, and, this is the important part, it can be used for commerce, it qualifies. And that's why the Great Lakes fall under Admiralty law. But some little isolated lake that's entirely inside one state? It doesn't.
Okay, now we're getting to one of the most powerful and, let's be honest, one of the weirdest parts of Admiralty law. This is a concept that has no real equivalent on land. Get this. You can literally sue the ship.
I know, it sounds totally bizarre, but this is a cornerstone of the entire system. Through this legal trick, basically, called an in rem action, you can file a lawsuit directly against the vessel. The ship itself becomes the defendant in the case. Wild, right?
And this whole process just shows you how powerful that idea is. So let's say a ship owes money for fuel, or maybe it causes a collision. A special kind of claim, a lien, attaches to the ship. A court can then order the U.S. Marshals to go down to the port and physically arrest it, literally chain it to the dock. For the ship's owner, this is an absolute nightmare. Their multi-million-dollar asset is stuck, it can't earn any money, and it's not going anywhere until they pay up or post a bond. It's an incredibly effective way to make sure people pay their debts.
All right, so the risks on the open ocean are just huge, right? And because of that, Admiralty law has some really specific and often pretty controversial rules for what happens when disaster strikes.
This is easily one of the most debated parts of maritime law. So under something called the Limitation of Liability Act, if a ship causes, say, millions of dollars in damages and then it sinks, the owner could potentially limit their total liability to the value of the vessel after the accident. So the value of the wreck itself, which could be next to nothing. Now, this is a huge protection for ship owners, but there's a catch. It only applies if the owner wasn't personally at fault.
And that is the key exception right there. If some high-level manager or the owner themselves knew the ship's radar was broken or that the crew wasn't trained properly, and that's what caused the disaster, well, they can't hide behind that Limitation Act. In legal terms, they had privity or knowledge of the problem.
And here's another one that'll make your jaw drop. There's this law called the Carriage of Goods by Sea Act. Everybody just calls it COGSA. Under this law, if your cargo gets lost or destroyed at sea, the shipping company's liability is often capped at just $500 per package. That's right, $500. It doesn't matter if that package is a box of paper clips or a crate with a brand new car inside.
The idea was to keep shipping costs predictable, but it means you absolutely have to declare a higher value and pay more if you want to be fully covered.
Oh, and the weirdness doesn't stop there. Not by a long shot. Even the way debts get paid off is completely upside down compared to how it works on land.
So on land, you know how it works, right? If a house gets foreclosed, the bank that gave the first mortgage gets paid first. It's first in time, first in right. But at sea, it's the complete opposite. It's last in time, first in right. The most recent claims, for stuff like fuel or emergency repairs or the crew's wages, they get paid before older claims, like the big mortgage from the bank. And there's a logic to it, believe it or not. The law rewards the people who provided the most recent essential services that allowed the ship to complete its voyage.
So if you look at this priority list, the really crucial takeaway is this. An unpaid sailor's claim for their wages gets paid before the multi-million-dollar mortgage held by a giant bank. It's just amazing. The law consistently, and I mean consistently, prioritizes the people and services that keep the ship physically operating over these big pre-existing financial deals.
Okay, so at this point, you might be thinking, wow, this is all kind of interesting, I guess, but what does any of it have to do with me? And the answer to that is pretty much everything.
I mean, that phone in your pocket, the shirt you're wearing, the coffee you had this morning, the odds are overwhelming that most of those things traveled here on a ship. And their entire journey, from start to finish, was governed by these strange and powerful principles of Admiralty law. It's like the invisible legal foundation of our entire global supply chain.
And what's really incredible is that its reach is actually spreading far away from the water. There was this landmark Supreme Court case that basically said if goods are shipped from overseas on one single contract, what's called a through bill of lading, maritime law can actually follow that cargo inland. So, get this, if a container gets damaged on a train in, say, the middle of Kansas, the case could be governed by the law of the sea, all because its journey started on an ocean.
And really, that brings us to the big question for today. You know, in this age of massive megaships, automation, and climate change, are these laws that were basically created in the age of steamships still good enough to protect our oceans and our economy? That is the question that modern courts and lawmakers have to navigate as the world of shipping keeps changing at lightning speed.